Today's seminar is educational only. It is not intended as legal advice or standard of practice advice. The opinions being expressed today by our learned panel are those of the panel and speakers themselves, and not any official position by the State Bar of Michigan. And our webinar today, being educational only in general, is not intended as legal advice and is not a substitute for your own research and application to the facts of your or your client's case. With that, let us talk about our brain trust. We have three great speakers today, and I'll keep the introduction brief because I know they've got a lot of smart things to say. Even though Tim Diemer from Jacobs and Diemer and Chris Desmond from Johnson Law, Ben Weitz, he paid me a little extra for the billboard, but it didn't arrive, and Beth Wittmann from Mark Ronzato's office have in common. Well, they are all brilliant lawyers, and they have done a significant body of work on behalf of the section. Between Beth and Tim and Chris, the work that they have done to enhance the scholarly work of the section has been phenomenal. In fact, Beth Wittmann's amicus brief in Doe versus Aplena was cited by the amicus committee as the model for legal scholarship that the section should be adopting. It should be the textbook. So these three speakers are not just legal gurus, appellate gurus, but they're also consummate professionals. They are giving, they are kind, they are courteous, they are civil, collegial, professional. They are the kind of lawyers that we should all espouse to be. We should all strive to be. With that, I'm going to turn the floor over to our panel.
All right. Thank you very much, Chad. As a past chair, we greatly appreciate your continued involvement as the, I don't know, Education Czar, Secretary of Education, something, because you put so much time and effort into our CLE events, and it's greatly appreciated, Chad. I hope you stick around forever. I think your appointment as Education Czar should be a lifetime appointment. That's my. Before starting on the 2023-2024 term, I think it's appropriate to call back to this webinar that we did 1 year ago. It was me and Beth Wittmann and Donna McKenzie. And the overarching theme of our presentation last year was that the 2022-2023 Supreme Court term portended a return of jury trials. Anecdotally, that seems to be 100% accurate. Again, there's no objective data to point that out. That's going to come later, but every trial attorney I know is trying case after case after case, having to adjourn trials because there's 2 or 3 going at the same time. That is a completely different experience than what I had when I first passed the bar in 2002. For the first 16 years of my career, jury trials were few and far between. Now the pace is unparalleled. And I think if we have time at the end, I'll maybe touch on that, of what we think is coming next. But a lot of those trials that occurred right after the COVID restrictions ended, end of 2021, early 2022, those cases are just now making their way to the Michigan Supreme Court. And the Michigan Supreme Court has not weighed in on trial practice in a very, very long time because there were very few trials. That's going to change. And I know that appeals from jury verdicts post-COVID are now at the time getting to the Michigan Supreme Court. That's a little maybe sneak peek of what I think is coming next term. One other callback to last year is I participated in a similar webinar to this for the Michigan Defense Trial Council, the civil defense bar. And I didn't come up with it, but the title of the presentation was An Uphill Battle. MDTC thought that El-Sayed and some of these other cases that came out last year were an indication that the defense bar was going to have a hard time in the Court of Appeals, the Michigan Supreme Court, based on what had happened. And that is completely wrong. Could not be more wrong than what we've seen over this past term. It is not an uphill battle. Maybe it's an uphill battle compared to the way the defense bar was received in the 2000s, 2010s, sure. But looking at the term that just concluded July 31, 2024, it's fitting that today's audience is half plaintiffs lawyers, half defense lawyers, because it was a draw. if you look at the opinions that were released, we're going to cover a lot of them today, not all of them, but there were a lot of, again, the term, wins for the plaintiff. There are plenty of, wins for the defense. The defense wins were 7-0. One of the cases I'm going to talk about is a 7-0 defense win. I believe Chris is going to cover another 7-0, defense win. So the idea that it's an uphill battle or the deck stacked against the defense is completely false. We have I hate to use the term fair and balanced, but the Supreme Court's term was fair and balanced. Split right down the middle, if you ask me. And my first case today is one of the defense wins. It's Dahmer versus Prime Healthcare. It's also called Juma. I'm not sure which it is. I always call it Dahmer. I hope Westlaw and Lexis can agree, and not one of them call it Dahmer, the other call it Juma. That will be a complete nightmare. I'll start with maybe the details of Dahmer and the conclusion from the court, and then move on to kind of the bigger picture takeaways that I came away with. Dahmer, like almost all medical malpractice cases, is a just depressing, horrific case. The decedent was a 13-year-old child who wasn't feeling well. His parents took him to the emergency room. Thanks, Matt. Matt's going to share the opinions as we go through them. The emergency room checked out the 13-year-old kid, thought he had some like muscle strain with his neck or something like that, sent him home. The next morning, the parents find him dead. He had meningitis, and it was not diagnosed. So his parents, on behalf of his estate, sued the doctor and the hospital that treated him. Early on in the case, the defense moved to dismiss wage loss damages. Again, the decedent was 13 years old, had no work history. Maybe he babysat, maybe on Little League baseball games or something like that. But he was not, like your typical plaintiff, 30, 40, 50 years old with some sort of work history. The defense moved to dismiss any sort of claim for economic damages related to wages. Trial court rejected the motion. It went up to the Court of Appeals. Now, that's kind of the structure of the case, but the legal issues, the analysis is a little more convoluted than that. The difference between the plaintiff's perspective and the defense perspective is whether the plaintiff can claim earnings impairment damages for what the decedent could have earned had the decedent reached majority, gone to high school, gone to college, gotten a job. What would the 13-year-old, what would his life have been like? What could he have earned? As opposed to the defense perspective of saying it's not what they could have earned, it's what they would have earned. And again, it's just one letter, C or W. Could have earned is earnings impairment. Would have earned is a completely different category of damages. Would have earned, you look at the plaintiff's work history, project their income into the future, and come up with a number. If in a case like this, if it's earnings impairment, could have earned, no need for a work history, no need for any sort of a track record of wages. But again, if it's would have, you've got to have some objective proof, some data on which to project the loss of income. And the differences are striking. So in Dahmer, the plaintiff hired an expert who said if the decedent had graduated from high school, he could have earned $11 million in future earnings. If he had gone to college and got a 4-year degree, he could have earned $19 million. Under the defense perspective, the decedent would get zero because he had no work history. So obviously for the plaintiff's bar, that's almost $20 million of damages that are either on the table or off the table. But then for the defense, for a kind of an entity, an insurance company, a corporate entity, trying to project what its exposure might be, that's a huge difference as well. Even if we allowed the earnings impairment, it could be $11 million or $19 million. That's an $8 million difference. That's huge. It also made cases much more difficult to settle with that kind of wide range of perspectives. So Dahmer goes to the Michigan Court of Appeals. Another case with almost identical facts called Vasquez also goes up to the Michigan Court of Appeals at the same time. Both cases are assigned to the same panel, and the same panel issues two different decisions at the end of believe it was 2022, at the end of December. And the Court of Appeals finds in favor of the plaintiff in Dahmer, saying to the plaintiff in Dahmer, the 13-year-old's income could be projected with reasonable certainty. But in the other case, and again, another horrific case, the decedent was a newborn, barely made it a day or two before passing away. And the Court of Appeals came to the conclusion in Dahmer, we have a 13-year-old, we know what his academic achievements are, we have his report cards, we can talk to his guidance counselors, we know his environmental factors, we know what his parents had earned, and we could reasonably project what his life would have been like down the road. Court of Appeals, the same law applied it to a different set of facts with a newborn, and said a newborn, it's speculative. We have no idea what was in the cards for a newborn, not even a kindergarten certificate, no elementary school, no anything. The Court of Appeals kind of issued a split decision where a 13-year-old earnings impairment, yes, newborn earnings impairment, no. And I can, when that came out, you know, the chatter among the lawyers was, this is going to be a very difficult standard to work. And the Court of Appeals opinion acknowledged that. Court said there's no bright line rule that a 13-year-old is always a yes, or a 13-year-old's always a no. There was no bright line rule. It's going to depend on the unique facts and circumstances of each individual case. Both parties, both defendants in Dahmer and Vasquez, appealed to the Michigan Supreme Court. There were two other cases that were also appealed to the Michigan Supreme Court right around the same time. And the Supreme Court had 4 different fact scenarios, 4 different cases it could have taken to decide the singular issue under the Wrongful Death Act. I'm gonna go off on a little bit of a tangent, but it's not really that much of a tangent. And it's gonna kind of go back to where I started. When the Supreme Court took this case, but not another one, lawyers with way too much time on their hands, with their tinfoil hats on, came to all these conspiracy theories that the Supreme Court picked this case, not the other, because in another case, one of the justices would have to recuse himself because of a family relationship with a party or something like that. And there are all these conspiracy theories that there was this one vote that was needed to get the decision across the line. So they took this case, not the other 3. I mean, it was ridiculous at the time when that theory came out. It's even more ridiculous in hindsight, because the Supreme Court took the case and the Supreme Court issued a 7-0 decision. It wasn't a close question. It wasn't 4-3, it wasn't 5-2. It was 7-0. 7-0 in favor of the defense. 7-0 in favor of a ruling that the estate of a deceased child cannot claim earnings impairment what the child could have earned. And there's another conspiracy theory about another case Supreme Court's taking up later, which I think should be set aside because it didn't happen here. It's just ridiculous because the grant of leave in Dahmer was 7-0. So that would require all the justices getting together and secretly coming up with this agreement to take one case or another because of the votes. It was absurd when it was surmised. It's even more absurd in light of the decision. So that's the background of how the case got to Michigan Supreme Court and what the Michigan Supreme Court decided. The bigger picture is that the Michigan Supreme Court, this is years ago, I believe it was 1957, issued a decision in a case called Baker versus Slack, which is illustrative of the difference between could have earned and would have earned. And Baker versus Slack was good law. It was essentially deemed to be repealed or overruled by the Michigan Court of Appeals. Supreme Court's disagreed in Dahmer and said, no, Baker versus Slack is still good law. So in Baker versus Slack, to illustrate the difference, the decedent was a widow. She had no spouse. She had no children who were depending upon her. She died, I believe it was in an auto accident. And when she passed away, she made a claim for wage loss. Her estate said, even though she didn't have any dependents, we want to get wage loss damages for her. The Michigan Supreme Court said no. The Michigan Supreme Court said that the Wrongful Death Act provides damages for loss of financial support, not for loss of wages. So because the decedent in Baker was a widow with no children dependent upon her, no family members dependent upon her, there were no economic damages for her wages because there was no one who depended upon her for loss of financial support. So in that way, Baker represents a way of viewing these cases as in a wrongful death case, whose life do we look at? Whose experience do we look at? Do we look at the person who passed away and what that person's life would have been had they survived, had they not died, and what they would have earned? Or do we look to the dependents and the beneficiaries and the heirs of the decedent? Baker says we look to the heirs and dependents of the decedent. Because there were no dependents, there was no loss of financial support. The decedent there was not entitled to any sort of economic loss for wages. That was the rule in 1957. The Wrongful Death Act had been modified in a number of respects over the nearly 60 years since then. And there were two important revisions to the statute that led the Michigan Court of Appeals in two different cases, primarily the case called Denny, 2016 case. Again, that's almost 60 years after Baker. The Michigan Court of Appeals and Denny didn't cite Baker versus Slack. That's one problem with the case. But the Court of Appeals opinion took a completely different view of the Wrongful Death Act and said, no, we're now going to look at it in terms of the decedent and what the decedent would have experienced had the decedent not passed away, as opposed to looking at the heirs. And Denny, the Court of Appeals allowed loss of wages for the decedent there, a guy in his 40s, as opposed to looking at what the guy's wife and children would have received as support. Denny was a 2016 decision. No one cited Baker versus Slack, not the parties of the case, not the Court of Appeals. It was appealed to Michigan Supreme Court. Again, no one cited Baker versus Slack until the very last minute, a reply brief in support of the application. At that point, it was too late. So Denny represented a completely different view of the Wrongful Death Act compared to Baker. And Denny was good law for 8 years until Dahmer came out and reaffirmed the rule of Baker, reversed Denny, reversed one other case that's similar called Thorne, and again, reinstituted Baker. We now look to the decedent's beneficiaries to determine whether there's loss of financial support. That's the narrow issue in Dahmer, but Dahmer is a much bigger case than simply one 13-year-old who passed away in a medical malpractice case. Dahmer is understood as a wrongful death damages case more than anything, whether it's medical malpractice, auto, product, any other mechanism that brought about a death, Dahmer is going to control. And Dahmer, I'm sorry, Chad, are you about to chime in?
Well, thank you for pointing that out. This doesn't just apply to medical malpractice cases. This is a case that will apply across the spectrum to wrongful death cases, regardless of the underlying tort that gets filtered through the Wrongful Death Act to survive by operation of law. And while Dahmer, the court expressly was dealing with this element of loss of earning capacity by a decedent, regardless of whether they had any surviving interested parties or dependents. The other issue that's going to be arising on a regular basis, or an area of future significant litigation that's anticipated, is the issue of loss of household services, the value that someone brings, the pecuniary value of a household member, such as a mother, a husband, someone that is caring for children, or other dependents. Tim, tell us what the read is on that, and the importance of footnote 10 in the Dahmer decision.
Yep, very good point, very good question, Chad. I mentioned that the wrongful death statute, subsection 6, which provides the damages, had been modified twice after Baker. One modification added the magical phrase that the jury may award damages that are fair and equitable under the circumstances. And the Court of Appeals took that language to say, well, what's fair and equitable under the circumstances is going to depend on a case-by-case basis. In one case, you might get this damage, in another one, you might not. There was another addition to the statute, and it was the addition of the word including. What's fair and equitable under the circumstances, including, and then blank. There were 6 different types of damages that were listed. And the Court of Appeals panel said the word including is not exhaustive. That means including, but not limited to. So those 2 modification statutes is how the Court of Appeals said Baker is no longer good law. So there was a view under Denny, again, until just about a month ago, that the wrongful death statute's designation of damages was not exhaustive, Different damages might be available in one case or another. And that view was rejected. The Michigan Supreme Court came out clearly, again, 7-0. There wasn't even a concurrence saying, hey, this result's really unfair. Legislature do something about it. It was 7-0, no concurring opinion. And the court said the word including is not an expansive word. If the damages are not listed in the statute, they're not recoverable. So there's not loss of earnings capacity is not there. So couldn't claim it in Dahmer. There are other cases. Chad brought up, what about household services? What about the household services the decedent provided? Can that be considered loss of financial support? Arguably, it could. And I think Chris might touch upon that one a little bit later. And in footnote 10 of the Dahmer opinion, there's a specific reference to household services. So maybe household services are still on the table. Dahmer did not decide that question definitively one way or another, but there's support for it. There's also support against it based on the language of the statute. And there are other types of damages that have been claimed and sought in cases that are not specifically provided for in the statute. And I can use one personal example. After Dahmer came out, my office is involved in getting a case ready for trial that's coming up in a few months. It's a trucking case. It's not a it's not a medical malpractice case, wrongful death case, but the concept of pre-impact fright and shock, the fear of impending doom. If someone sees a truck barreling down on them, or they're in an airplane that's about to go down, can they get the damages for pre-impact fright and shock? Well, the statute says the decedents can get compensation for the time intervening, conscious pain and suffering intervening between the time of injury and death. Pre-impact fright and shock is something different than that. So there's an argument there that pre-impact fright and shock is not compensable under Dahmer because it's not specifically included. So that's, again, in my perspective, that's why this is a bigger opinion than just one particular sort of circumstances, one 13-year-old child. It's going to cover wrongful death damages across all cases. And I will conclude my remarks on Dahmer. I'm going to try and do this for all the cases that I'm going to cover with what I think is the money quote, the most important quote of the case. And here it is important for the case itself, but it's also important for the section and what the section stands for. This is at page 21 of the opinion, which Matt was good enough to link. And this is from Justice Viviano's unanimous 7-0 opinion. It says, as noted above, in our legal system, the jury determines the amount of damages and the court determines what types of damages are available. Allowing the jury to have complete discretion as to the types of damages that are available would be quite a departure from this legal norm. Again, judge decides the law, jury decides the facts, encapsulated in two succinct sentences there on this decision. Chad, unless you've got questions or any other questions came through the chat,
We're good to go on to the next case.
Okay.
Okay, I'd be happy to talk about the next case. And I think this is the most important case that came out this term that I will be talking about. This is the Stokes/Horn versus Swofford case and the Selliman versus Colton case. Now, these two cases, they deal with the expert witness qualification statute, which is MCL 600.2169. So under 21691, a person cannot give expert testimony on the appropriate standard of practice or care unless the person's licensed as a health professional in this state or another state. And this is the important part. If the party against whom or on whose behalf the testimony is offered is a specialist, the expert has to specialize at the time of the alleged malpractice in the same specialty as that party. And additionally, under 21691, the expert must devote a majority of their professional time in the year preceding the alleged malpractice to the active clinical practice or teaching in that same specialty. So a little bit of history on the expert witness qualification statute. The Supreme Court previously had looked at this statute in a case called Woodard v. Custer, and that was in 2006. And they interpreted 2169 and held that an expert must match the one most relevant specialty. So that's the specialty that was engaged in by the defendant physician during the course of the alleged malpractice. So the Woodard court said that if at the time of the alleged malpractice, the defendant physician was practicing in a particular branch of medicine in which one can potentially become board certified, then the expert also has to specialize in that same specialty and has to have practiced in or taught that same particular branch of medicine for a majority of their professional time prior to the alleged malpractice. So the Woodard Court further held that a defendant physician specializes in a subspecialty, and if they're certified in that subspecialty at the time of the alleged malpractice, then the expert also had to be certified in that same subspecialty. So just as a practical matter, application of Woodard's one most relevant specialty test was really, really difficult. It was incredibly complicated. There were experts that were very, very qualified that were deemed not to be qualified. There were even experts, defendants who were not even able to testify on their own behalf because they weren't qualified under the statute in the way that it was interpreted by the Supreme Court in Woodard. So it caused some problems. Now, I think just a little bit of a flashback, the Woodard courts, the majority that issued this decision, they were trying to prevent what I think would be an even worse situation, which was the dissenting justices, I think, were advocating for, you had to match all specialties, even the irrelevant ones, the ones that had absolutely nothing to do with the care and treatment. And that would have been a disaster. I mean, if you had, sometimes doctors have a board certification in, say, OBGYN, but they're practicing as a cardiologist. You'd have to find a board certified OBGYN that practices cardiology. I mean, it would have been a disaster. So this was the lesser of two evils, but it still wasn't quite so good. So in the Stokes case, the facts of that case, the plaintiff filed a medical malpractice complaint against Dr. Swofford, who was a physician who verified the results of a CT scan that was performed on the decedent. Dr. Swofford was a board-certified diagnostic radiologist at the time of the malpractice, but he had also obtained a certificate of added qualification in neuroradiology, which is a subspecialty of diagnostic radiology. But the certificate had actually expired by the time of the malpractice. Dr. Swofford also was previously the chief of neuroradiology at the hospital before the alleged malpractice. So plaintiff in this case filed an affidavit of merit that was signed by a physician who was specializing in neuroradiology, believing that that was the one most relevant specialty in the case. Dr. Swofford, however, the defendant, signed his own affidavit of meritorious defense and stated that the applicable standard of care was that of a diagnostic radiologist. So the Court of Appeals held that Dr. Swofford was in fact practicing neuroradiology when he interpreted the CT scan of the decedent. In the Selliman case, the plaintiff filed a medical malpractice claim against Dr. Colton, who was a board-certified otolaryngologist, which is an ear, nose, and throat specialist, or an ENT. So Dr. Colton also was board-certified in facial, plastic, and reconstructive surgery. And plaintiff's expert held actually the same certifications as Dr. Colton. But the defendants moved to strike the plaintiff's expert on grounds that the specialty at issue was in fact facial, plastic, and reconstructive surgery, and that plaintiff's expert didn't devote a majority of his professional time to that same specialty that at the time of in the year preceding the alleged malpractice. And the trial court concluded that the one most relevant specialty was facial, plastic, and reconstructive surgery, but declined to strike the plaintiff's expert because he held there was a question of fact as to what the expert actually was practicing. So the Court of Appeals reversed and held that the trial court properly determined that the one most relevant specialty was facial, plastic, and reconstructive surgery, but the court abused its discretion in failing to strike that expert. So the plaintiffs in both Stokes and Selliman sought leave to appeal from the Supreme Court, and the Supreme Court granted leave to appeal and then heard and decided both cases at the same time. So the holding of the Supreme Court is that they concluded that Woodard was wrongly decided in part, and they held that the test that was adopted by the Woodard Court regarding the evaluation of specialists is inconsistent with the plain language of 2169. Specifically, the court held that the Woodard Court incorrectly conflated the two terms of specialty and subspecialty in a manner that was inconsistent with the language of 2169. So the court held that the word specialist and specialties as used in 2169 is defined by the specialties that are recognized by certain national boards, like the American Board of Medical Specialists, that's the ABMS, the American Osteopathic Association, the AOA, the American Board of Physician Specialists, and then they say, or other nationally recognized physician umbrella certifying organizations, whatever those might be. So we'll see what that might boil down to in the future too. But the court held that the important takeaway for this one is that the matching requirement under 2169 is only for those general board certifications, not for any subspecialty certifications that may also be recognized by those boards. So the court also held that, and this is important too, that the Woodard court kind of failed to analyze the other parts of 2169, specifically 2169-2 and 3, which mandates the trial courts to review the educational and professional training of the expert witness, the area of specialization of the expert witness, the length of time that the expert witness has engaged in the active clinical practice or instruction of that specialty, and the relevancy of the expert witness's testimony. In subsection 3, it specifically says that the section does not limit the power of the trial courts to disqualify an expert witness on grounds other than qualifications that are found within the statute under 2169. I always have taken that to mean they can disqualify them for reasons under MRE 702. So the holding in Stokes, the specific holding, was that the one most relevant specialty in that case was in fact diagnostic radiology, because that is the general specialty under the ABMS, and that the defendant held and practiced that specialty. So that was the only specialty that had to be matched. And the holding in Selliman, the court remanded to the trial court actually for determination of whether facial, plastic, and reconstructive surgery is a subspecialty rather than a specialty. And I think it's interesting, when they decided that Woodard should no longer exist, at least in part, the court really did recognize that Woodard really defies practical workability, and that it led to inconsistent and untenable results. And they really pointed to these two cases to say, this is exactly why. This is why this has been a problem, and we need to fix it. So my takeaway for this one is that, obtaining an expert in the one most relevant specialty now should be a heck of a lot easier for everyone. The expert only has to match that general board certification for purposes, at least for purposes of 21691. But keep in mind that the trial court also has to ensure that these experts with these matching specialties meet the criteria set forth in 21692 and 3. And the courts do then have the discretion to determine whether an expert is qualified under those provisions. And like I said, under MRE 702 as well. So.
Well, before we move on from this case,
Yes,
we want to take a minute to thank Beth and Mark Ronzato for the substantial work that they did in the briefing, in 4 briefs essentially, because we have the two cases, and amicus briefs were submitted by the Ronzato firm on application to leave, and then on a leave granted. And this was an area that the section had a significant investment of time and resources in. Jenna Wright-Greenman from Kitch, Beth was involved, myself and Donna McKenzie. This issue of expert qualification was one that was affecting both sides, causing increased cost, uncertainty, and litigation, and there were some really absurd results, as Beth pointed to, of people not being able to defend themselves. That is, someone who was qualified to perform a procedure or a test, but not qualified to testify about it in court, and experts being deemed to be, quote, overqualified to be experts.
Yeah.
This was a section, an issue that the section identified as one that was affecting both sides, and more importantly, was causing a disruption for and uncertainty for litigants and causing excessive litigation and resource drain on the court system. And hopefully, while there may be some initial shakeup in terms of how the cases that are pending might be applied, hopefully the clarity that Stokes and Swofford and Selliman provide will enable a more efficient litigation of the process. But I really do want to thank Beth and Mark Ronzato, an absolute legend in the appellate world and in medical malpractice, and probably someone who has submitted more amicus briefs on behalf of the section than every other writer, every other lawyer combined. Mark Ronzato has been the lodestone, the cornerstone of the the section's amicus efforts. So thank you, Beth and Mark, especially for your work in this case.
Absolutely,
So
of
many
course,
others.
anytime. And it is, that is a very good point. I mean, this decision, it should make things easier for both plaintiffs and defendants. I mean, this across the board should really, really assist in making this a lot easier. And, it's good too. We have better decisions now on affidavits of merit and affidavits of meritorious defense. But, for a very long time, cases were getting dismissed, defendants were getting defaulted based upon, lack of expert testimony. That should be a little bit better. So.
Beth, we have a question from the audience.
Okay, good.
A quick question, and it's a really astute point. The question is, does the Stokes opinion affect at all the longstanding rule in medical malpractice that a physician practicing as a resident is to be held to the standard of care of any other physician practicing that specialty? To use your example, and that was the case in the published case on point, Gonzalez versus St. John, an obstetrician who is practicing as a resident, are they held to, as a physician, the same standard of care, a national standard of care under the statute, as someone who has completed their residency and is acting as an attending or a faculty member? I know that wasn't addressed in the Stokes case,
Right.
And Woodard was only overruled to the extent it was in conflict. Would that be something that, do you have any sense of how that's going to evolve?
I don't, it'll be interesting though, because, the whole point of Gonzalez was that, these are doctors in training, they're not specialists really in anything. So I don't know that this is going to necessarily subject them to a national standard or anything like that. But I mean, we'll see what arguments come up after this. But at least for, because for Gonzalez, they held as long as somebody is familiar with the standard of care that is applicable to that resident, then they would be qualified to testify. And, I think how this decision from the Supreme Court is going to apply is that if somebody is a fellow, for example, and doing some sort of subspecialty, I think you're really only going to have to look at the specialty certification. So I think that maybe will help a little bit, perhaps, in finding experts, but I don't know that it's necessarily going to change the standard of care that applies to a resident physician.
All right, Chris.
I think we're. Oh, I'm sorry, Chad. I didn't mean to interrupt you.
No, please go. If I remember the rotation right, you're up.
Yeah, I think we're transitioning into my first case, which I'm going to be covering a Elliott Larson Civil Rights Act case for the group today. And the case is Doe versus Aplena Public School District. This is Michigan Supreme Court number 165441 for those who want to look it up, although I know the opinion is going to be placed down in the chat. So to give everybody an idea, first of all, the reason why this is such a significant case to cover is because it deals with an issue of first impression for both the Court of Appeals and the Michigan Supreme Court, which is whether or not a school district can be held liable for a hostile education environment arising out of student-on-student harassment. And so to kind of make that description make sense to everybody, I'm going to jump into the facts of the case a little bit. And so this is a case that involves two fourth grade students inside the Aplena Public School District. because they're children. We don't identify them by name. So we have John Roe and Jane Doe. Throughout the course of her 4th grade year, Jane Doe was victimized by John Roe, both physically and verbally. He was physically touching her inappropriately, and he was making improper comments toward Jane. And in each instance when this would occur, Jane would take her complaints. She would verbalize her complaints, and she would inform the school of what happened. And the school would take some action. At issue in this case, one of the things that's at issue and that I won't be opining on is whether or not the school's response to John Roe's conduct was proper and appropriate. But in each instance, the school responded in some way, whether it was invoking an in-school suspension on John Roe, limiting or attempting to limit John's access to Jane by not letting them be in the lunchroom at the same time, not letting them sit near one another in a classroom. But the events continued. The harassment continued. Jane continued to complain. The school continued to take some steps that Jane found to be inadequate. And ultimately, during her 4th grade school year, Jane left the school that she was in and transferred to a different school in the district. And so for roughly the next 2 school years, Jane proceeded in the school district incident-free. And then when she ended up in junior high, she went to a new school, and John Roe was placed in the same school as her once again. And so her family, through an attorney, had contacted the school district ahead of time to let them know about the no contact order that had been put in place between the children, and trying to ensure that the process in the new school would be smoother than it was in the last school that they were in together. But unfortunately, the acts of harassment continued in this new school. The students were assigned to the same bus and were placed on a bus together. While on that bus, John continued to harass Jane. Jane ultimately left the Aplena public school district and transferred to a private school. John was ultimately, and by the way, I should mention, because I do think that this could potentially have some relevance. It was referenced in the opinion, though it didn't become particularly material, but John was a student who was under an IEP. He was suspected of being developmentally delayed, although that wasn't confirmed during the course of the litigation and during discovery, but it was confirmed that he had severe speech impediments that, from my reading of it, essentially rendered him nonverbal and in need of a constant aid while he was in the school setting. But John eventually, after Jane transferred out of the school system, John assaulted another female classmate and was expelled from the Alpena's public school district. So fast forwarding to the case, when Jane brought suit, the Alpena Public School District, she did so, first of all, on 2 bases. We're only going to discuss one today. She did so on the basis of the Elliott-Larsen Civil Rights Act under a hostile education environment theory. And then she also brought a gross negligence claim under the Governmental Tort Liability Act. That claim went away prior to the case being taken up by the Supreme Court, so it's not at issue in today's discussion. But relative to the Elliott-Larsen claim, the defendant responded with a motion for summary disposition pursuant to C8 and C10. Pursuant to C8, the district argued that Elliott-Larsen doesn't recognize a cause of action for hostile education environment that's premised on student harassment. Their argument was the district itself can't be held liable for Roe's harassment of Doe. But then they also argued pursuant to C10 that even if Elliott-Larsen does recognize such a cause of action, the plaintiff failed to establish a genuine issue of material fact relating to all the necessary elements of the claim. The trial court agreed on all regards. The trial court agreed that Elliott-Larsen doesn't recognize such a claim, but that even if it does, plaintiff hasn't met her burden in this case, and the case was dismissed. The plaintiff appealed to the Michigan Court of Appeals, and the Michigan Court of Appeals affirmed the grant of summary disposition, but only pursuant to MCR 2.116C10. The court agreed that there were no genuine issues of material fact, but the court disagreed regarding whether or not Elliott-Larsen provided for a cause of action for hostile education environment. And this is where, because it's an issue of first impression, this is where this case gets a little bit messy. And, advance warning, there's not a conclusive answer about what's going to happen in this cause of law. It's sort of a to be determined opinion, I think, in a lot of ways, although I'm not sure that that's the way the legal community saw it when it initially came out. But what the Court of Appeals did is they said, when you look at Elliott-Larsen, it treats education and employment as being an equal right. You have a right to education just like you have a right to employment. And if we recognize hostile employment environment claims or hostile work environment claims under Elliott-Larsen, it follows that we should have the same in education environments. And so the court consulted, which is one of the seminal cases in hostile work environment litigation, which is the Ratke versus Everett case. This is a 1993 opinion of the Michigan Supreme Court. And that case lays out what the elements are for a hostile work environment claim. It's got 5 prongs. They're pretty quick, and I'm going to read through them for everybody while telling you in advance that in Doe, the only prong that became relevant and that we're really going to be talking about today is the 5th and final prong. But the Ratke test, the first prong is that the employee belonged to a protected group. The second is whether the employee was subjected to communication or conduct on the basis of sex. The third is that the employee was subjected to unwelcome sexual conduct or communication. The fourth is that the unwelcome sexual conduct or communication was intended to, or in fact did, substantially interfere with the employee's employment or created an intimidating, hostile, or offensive work environment. And then the last prong, and this is the one that has kind of complicated this case, is respondeat superior. And so in a typical hostile work environment where employee A is trying to hold the employer responsible for an environment created by employee B, they have to show that there's a respondeat superior relationship between employee B and the employer. Well, the Court of Appeals said that doesn't work in the context of a student-on-student harassment case because John Rowe is not the agent in a respondeat superior context of the Aplena Public School District. But the court said, but we have something else instead of respondeat superior. Instead of respondeat superior, in a school setting, we have in locus parenti, which essentially says that a school is operating during the course of the school day, operates sort of as a guardian or parental figure over those students and has a degree of control over the students that have been entrusted to them. And so the school said that we can, or the Court of Appeals said we can plug in the in loco parentis analysis into that 5th prong in replace of respondeat superior. But again, they affirmed the dismissal of the case, saying that under C10, there were no genuine issues of material fact. So the plaintiff appealed to the Michigan Supreme Court and the court granted leave. And ultimately, the court came down with, we have 3 opinions here to discuss. So the majority opinion was written by Justice Viviano, and Justice Viviano was joined by Justices Zara, Clement, Welch, and Bolden. And what the majority held is that while there is a claim for hostile environment that exists under Elliott-Larsen, the test that's given to us in Ratke that contains respondeat superior, that is the applicable test. And contrary to what the Court of Appeals said here, you can't just substitute out the respondeat superior test. And the reason for that, the court said, and by the way, as a side note, I know that some of the areas that we're going to discuss today might seem like they're very hyper-specific. You might not be an Elliott-Larsen Civil Rights Act practitioner or a medical malpractice attorney practitioner, but I do think that there's reasoning in all of these cases. There's sort of common threads that we can see. And so in this case, the court went to the text of the Elliott-Larsen Civil Rights Act, and they said the Ratke test is logical because it's invoking concepts of respondeat superior because Elliott-Larsen invokes principles of agency. When Elliott-Larsen defines employer, when Elliott-Larsen defines educational institute, it also references the agents of those institutions. So the Michigan Supreme Court said that while the Elliott-Larsen Civil Rights Act references concepts of agency, it doesn't reference principles of in loco parentis. And so it was improper for the Court of Appeals to substitute that into the Ratke test. And so the court said that Elliott-Larsen does not recognize a cause of action for hostile educational environment premised on student harassment if it's a vicarious liability claim. And I think that's very important to note. The court was really focused on whether you can get liability from the school through a vicarious liability theory. And they said you can't. And so they vacated the opinion of the Court of Appeals. They didn't remand back to the trial court just for dismissal of the case. They remanded back to the Court of Appeals with instructions to determine whether or not the plaintiff has a claim for direct liability against the school district as opposed to vicarious liability against the school district. Again, for the same events, for the acts of John Rowe harassing Jane Doe. The The court remanded for, with instructions to determine whether or not there are genuine issues of material fact relating to that claim, and then stated, and to the extent that it's necessary, whether such a claim exists. And so it appears in a way that this case is going back to the Michigan Court of Appeals, largely in the same state it was in when it got to the Michigan Court of Appeals, which is in a sort of uncertain environment regarding what is school liability when we have one student harassing another student, and the school is alleged to have not taken proper steps to remedy or stop that hostile conduct, or remedy that environment that the student has been subjected to. Now, Justice Kavanaugh wrote a concurring opinion where she agreed that there wasn't a claim based on vicarious liability, but she noted that the plaintiff's theory in this case the entire time has been an actionable claim, that a district should be able to be held liable for a hostile educational environment that arises out of an improper response to student-on-student harassment. And so I think that the words in Justice Kavanaugh's concurring opinion are probably going to be a large focus of the parties on remand and of the majority or of the panel on remand. Finally, there was one last opinion, which was by Justice Bernstein. Justice Bernstein dissented completely and said that he would recognize, he'd agree with the Court of Appeals that there is a claim for hostile educational environment that arises out of student-on-student harassment, and that he thinks it can come out of a vicarious liability structured argument. And that, like the Court of Appeals, he agrees that you can substitute in other doctrines for that doctrine of respondeat superior that comes from the Rathke test. But in terms of final thoughts on the case, I think all I would say is that, this is a case where the court once again focused very heavily on what the statutory language was and looked for some statutory justification for the test that was created by the Michigan Court of Appeals or adopted by the Michigan Court of Appeals in this case. Anytime you have an issue of first impression, it's going to be difficult for courts to figure out what should sort of the margins of this cause of action be, and how do we figure out what the elements of such a claim are. And so that's where I want to draw a little bit of attention once again to Beth Wittmann in regard to this case, because Beth and Mark Granzato did an amicus brief for the section, and because the section, and I've experienced this myself in the past doing amicus briefs for the section, because the section is made up of a mix of plaintiffs' attorneys and defense attorneys, we have to be able to come to a consensus on points from both sides before we can really throw our hat in the ring and support any one particular position in a case. And in this case, the section's position through Beth essentially was that when you're dealing with an issue of first impression, and a court is going to be giving a new test and providing a new structure to people regarding how you can pursue a remedy and what that remedy looks like, it's in the best interest of all the parties after that test is created through the appellate system for the parties to be able to reopen discovery and go through certain procedural steps in the litigation process that are now geared toward that new test. Because in fairness to all parties, if a test isn't created until after the case has gone through discovery, after the parties had formulated theories, and now the Court of Appeals comes down with a new test that those parties weren't contemplating when they were involved in those steps, one party could be at a major disadvantage. And so the section, on behalf of all of its members, was seeking to avoid that type of an outcome in this case. Because there was no real new test created in this case by the Supreme Court yet, that's still to come. It remains to be seen whether or not the courts will take the section up on that invitation.
All right, we have no questions pending for Chris. Tim, we're going to shift to you. Just from a timing perspective, we are at 1 o'clock, so that everyone knows we're going to complete all the cases that we have slotted. We may run over on time. If people have to leave, other conflicts or events, we completely understand that. Thank you for your participation. This program will be available for all section members and all attendees. You'll get an email. It will be on the section's archived website, on the State Bar website, and we'll also post it to our social media channel on YouTube, and you'll have a link to that. So with no further ado, Tim, turn it over to you.
Hey, thank you, Chad. And we also on the YouTube page timestamp each case. So if there's one case you're particularly interested in learning about, you can go right to that timestamp mark. My next case, yeah, Chad's right. We're 2/3 of our way in terms of time and only 1/3 of the way in terms of the case we want to discuss. So I will pick up the pace a little bit here. My next case is Danhoff versus Dr. Fahim. It's the third recent Supreme Court opinion to examine the role of medical literature to support expert opinion. The two prior cases were Edry and Elher. In those two cases, the expert was struck because the expert did not have peer-reviewed medical literature in support of the proposed expert opinion. In Danhoff, on the other hand, the court held that supportive literature is one of the 7 factors for reliability, and the absence of literature is not dispositive. And the court reaffirmed the flexible nature of Dahmer challenges, and Danhoff is a perfect example of why the flexibility is important. In Danhoff, the plaintiff suffered an extremely rare complication from an extremely rare surgical procedure. Not surprisingly, because again, the rareness of the procedure and the complication, there were no peer-reviewed medical articles to discuss the complication that the plaintiff suffered there. It was perforated colon during a spinal procedure. The plaintiff's expert, the standard of care expert, did look through PubMed and other resources to try to find some supporting literature, but couldn't find anything. The only thing the expert could find was that there's a 1% chance of this complication from occurring, but there was not much of an analysis of how and why the complication would occur, just that it's extremely rare. So the plaintiff's expert did his due diligence, tried to find medical literature to support the opinion, but just couldn't find anything. The trial court struck the plaintiff's standard of care expert based on a lack of supporting literature without considering any of the other 6 factors the court's supposed to look at. Just one was missing, therefore the expert was gone. The Court of Appeals affirmed, and the Supreme Court ultimately reversed. It was a 5-2 decision. Again, in Elher and Edry, the Supreme Court in Danhoff didn't modify, criticize Elher or Edry at all, but operated within the same framework of Elher and Edry, but came to a different conclusion. In Elher and Edry, the proposed experts did not have medical literature in support of their opinion, but there was an additional problem with their opinions. The difference between Danhoff compared to Elher and Edry was that in Elher and Edry, the proposed opinion was not only not supported by medical literature, but was actually contradicted by it. So in Elher and Edry, the defense came in and said, the plaintiff's expert has no medical literature, and here's medical literature that says the plaintiff's expert is wrong. That last piece of the equation was missing in Danhoff. The defense didn't come in and say, Ms. Danhoff's expert has the literature and his opinion is contradicted by literature. There was no literature. There's a complete absence of it. That was the key distinction between Danhoff, Elher, and Edry. I will note, Justice Bernstein filed a concurring opinion and just said, I don't think we should continue to follow Elher and Edry. I'm not sure exactly what the criticism of those 2 decisions would be. He didn't really specify, but he said, I'm not sure if they're still good law. We should continue to follow them. And in a lot of the cases we're talking about today and cases we talked about last year, a lot of times the new change in law that comes to Supreme Court opinion was previewed in a concurring opinion or a dissenting opinion. The Justice Viviano signaled the Dahmer decision, can't remember the name of the case off the top of my head, it was Tuma from a couple of years ago. The basis of the Dahmer decision was right there in a dissenting opinion when leave was denied, said, hey, we really should take this case up, and here's what the result should be. Justice Bernstein is signaling that there might be some weaknesses to Elher and Edry, that future challenges could be made. In addition to that synopsis of the opinion, there are 2 other quick notes about Danhoff. One, as a general practitioner, I really appreciate Justice Bolden's use of explanatory footnotes to go through all of the medicine and the science. A lot of med mal lawyers speak their own language and just presume everybody else is fluent, and not all of us are. So I really appreciated the explanatory comments. And then also the money quote from Danhoff, which I think just really gets to the fairness of the situation. It would be, really unfair to Ms. Danhoff to say, hey, what happened to you was so rare and bizarre. You're out of luck because there's no literature to cover, 1 in a million chance. And that really was found in the Supreme Court's opinion. The quote in Danhoff that I really like is from page 23. And it's, if the failure to produce medical literature means that a plaintiff's otherwise reliable expert opinions are inadmissible, patients who experience complications so rare that they are not studied by the academic community or discussed in peer-reviewed publications would not be able to offer admissible expert opinion when seeking legal recourse for their injuries. Common sense makes, completely fair to the plaintiff who suffered an extremely rare occurrence, that our expert did his best to try to find something, but couldn't because there was nothing out there. And the opinion said that the claim can go forward.
All right, we have no questions pending yet. So Beth, back
right.
to you.
All right. Okay. So the next cases that I'm going to talk about is our Carter versus DTN Management Company and Amijo versus Bronson Methodist Hospital. So the issue in these two cases is whether the Michigan Supreme Court had the authority to issue the administrative orders that were issued during the COVID-19 pandemic that actually, and I'll put this in quotes, told the statutory limitations period in which a plaintiff could file suit, and whether they rendered the plaintiff's claims in these particular cases timely. So the facts, I think everybody knows, the Michigan Supreme Court issued several administrative orders during COVID, excluding any days that fell during the state of emergency that was declared by the governor for purposes of determining deadlines for commencing civil actions. So the plaintiffs in Carter and Amijo both relied upon the administrative orders and filed their lawsuits after the limitations period had expired as to their claims. The Court of Appeals in Carter determined that the administrative orders were constitutional and held that the running of the limitations period in that case was in fact told by the administrative orders. The Court of Appeals in Amijo, however, determined that the administrative orders do not toll the 182-day pre-suit notice period that's set forth in MCL 600.2912B. And therefore, the plaintiff's claims in that case were untimely when they were filed. The Court of Appeals held in Amijo that there was the amended administrative order number 2020-3 that plainly indicated that a statutory period that had to elapse before the commencement of a medical malpractice action, which the pre-suit notice of intent fell within that, that meant that that continued to run during the state of emergency. So the Supreme Court granted leave to appeal in Carter and granted a MOA in Amijo. And I hope everybody knows that MOA is a mini oral argument on the application, just in case everybody's wondering what the hell I'm talking about. So speaking of our own lingo. So the holding in Carter, the Supreme Court actually affirmed the Court of Appeals and held that the administrative orders were in fact constitutional. They held that they had the inherent power to control the administration of justice throughout the state. So the court was very clear in saying that the administrative orders did not toll statutes of limitations, but instead affected the counting of the relevant time period under MCR 1.1081. So the court found that affecting this computation of days by the administrative orders was well within the judicial power of the Supreme Court because it falls within their authority to modify, amend, and simplify the practices and procedures in all courts in the state. The court held that MCR 1.1081 works in concert with statutes of limitation to guide the parties in the state as to how and when they're going to file their action. And they made it similar to like how you don't have to file during a weekend or a holiday or the times that the courts are closed. This administrative orders, they explain that the state of emergency that was enacted by the governor was a similar type of act or event that was not to be included in computing the time in which to file these actions. So the court concluded that the AOs therefore were constitutional exercises of the court's constitutional powers. The court also held that they were valid exercises of the court's reserved power to exert superintended control over all courts. And they really, this was Justice Bolden, she said that there was exigent circumstances requiring the court's actions to safeguard the courts So the Constitution authorized the court's exercise of this power in adopting these administrative orders. They noted that courts were closed and, people didn't have access to the courts. This was a big problem, that the courts were able to step in and help all people within the state. Amijo, though, the Supreme Court ultimately denied leave to appeal after holding the MOA. And that left in place the Court of Appeals decision that the administrative orders do not, in fact, toll the pre-suit notice period. So the takeaway then, the administrative orders that were issued by the Supreme Court are constitutional. They did, in fact, extend that time for the deadlines in which to file an action. But if any reliance upon them was made for the pre-suit notice period, that is not going to work to render your claim timely, and that's only applicable to medical malpractice claims.
Well, thank you, Beth. Definitely a complicated factual interplay, but the court came down with a very succinct analysis. For legal observers, I don't think it was much of a surprise.
No, I don't think so. I mean, she had a couple pointed placements in the opinion where she said, that this court issued these administrative orders without dissent. That's a real, she was pointing at the fact that two of the justices who are now dissenting didn't dissent at that time. So, without calling them out necessarily, it was pretty clear, we did this for a reason at the time, and let's not forget why we did it.
Exactly. Have to keep the court door, the access to justice open during an unprecedented situation in our nation's history.
Exactly.
We have a question.
Okay.
It is on the Doe versus Aplena case. So both you and Chris, open door here. The question is from Mark Bernstein: how specific must the hostile activity be between the plaintiff and the defendant? And he's referencing issues that are occurring on college campuses. And he's specifically concerned about specific actions of individual students, but also targeting groups of students. And I'll probably cut to the chase and say, Mark, that those are issues that are unaddressed in the Doe versus Aplena case. Perhaps when it goes back to the trial court and then up to the Court of Appeals, those issues may be elucidated. But it is important to note that the Doe case, the Aplena school case, was a primary school case, not a college case. And there were issues because of control, the right of control, for example, and prior knowledge. So all of those issues and the factual development that hopefully will take place in the trial court may inform the later development in this area of law. And then how it is applied in primary versus higher education versus college may be a distinction as well. Does that summarize that well, Beth and Chris?
Yeah, I think so.
Yeah, I think so. I'd just add, Chad, in Doe, we were dealing with very specific targeted acts between John Roe and Jane Doe. And so there wasn't any need for any court to discuss that sort of less direct version. I know right now, and I don't know if this is what Mark was thinking, I know right now we obviously have a lot of situations occurring on college campuses with a lot of the political discourse that's going on. The test from Ratke that was really at issue in Doe versus Aplena was a test that was geared more toward concepts of sexual harassment. And so I think that when you're dealing with more of the political environments that we're dealing with right now, you're going to be bumping more into freedom of speech issues that could complicate things beyond what's contemplated by the Doe case.
Right. All right. Well, Chris, since you're unmuted, we're rolling right on to you. Keep the ball
All right,
rolling.
great. So my next case is again a sexual misconduct case. This is a case called McLain versus the Roman Catholic Diocese of Lansing. And it's Michigan Supreme Court number 165741. Full disclosure, this was my case at the Michigan Supreme Court and the Michigan Court of Appeals. I represented Brian McLain. This is not a case that involves the Elliott Larson Civil Rights Act. This is a case that involves a statute that was enacted by our legislature in 2018 while we were in the midst of the Larry Nassar scandal, and it's MCL 600.5851B. And so a very, very brief overview of the facts of this case. Brian McLain is, I believe he's my age. He's in his early 40s. In 1999, Brian was a teenager who was residing at the Maxie Boys Training School, which is essentially a juvenile justice facility While there, Brian was sexually assaulted by a priest who was assigned to the Diocese of Lansing, who was serving essentially providing chaplain services, or supposed to be providing chaplain services to the juveniles at Maxie Boys Training School. So, Brian, like many individuals who are at Maxie Boys Training School, he had already had a complicated life, complicated emotional history, but that emotional history changed significantly after the acts of abuse. And Brian began experiencing depression, post-traumatic stress disorder, and issues relating to addiction. And just so everyone knows, this is out in the case, and Brian talks about all of this very openly. He's doing very well today with his recovery and is proud of the efforts he's made. So I'm not sharing anything Brian wouldn't want me to talk about. But Brian, for years, suffered from these different experiences or these different conditions, not really associating them with the abuse that he had occurred. He knew he experienced abuse, but Brian didn't know the science of child sexual abuse and doesn't know the sort of things that can result from it. And so it wasn't until 2020 when Brian was meeting with a therapist and he disclosed those acts of abuse for the first time that the therapist helped Brian understand that a lot of what you're dealing with is directly connected to that abuse that you experienced back when you were a teenager. So Brian contacted our firm in 2021 after that meeting with his therapist in 2020, and we looked at this newly passed statute. And one of the provisions in the statute, so what the statute attempts to do two things. So MCL 600.5851B starts by saying that a victim of criminal sexual misconduct as a minor, they have until the age of 28 to bring suit, or they have until 3 years from the date that they connect those acts of sexual misconduct to the damages that they've been experiencing or the damages they incurred. And so our thought was Brian didn't make that connection until 2020. The statute was enacted in 2018, and so the statute applies to Brian's facts. We brought suit. The Diocese of Lansing disagreed with our interpretation of the statute and said that we really needed a retroactive application of the statute. We needed to be able to say that that statute that passed in 2018 applied to people who were assaulted in 1999. Not to get too technical into the argument, but we argued that this wasn't an issue of retroactivity. This was more of an issue of accrual. And it's about when does a cause of action accrue? And our argument was that the Michigan legislature had essentially created a discovery rule, which used to exist in the common law in Michigan, but now it only exists in area by area instances. And so we argued that in this instance, the Michigan legislature created a discovery rule that would apply to these cases, and Brian should be able to utilize it. The trial court agreed with our position and denied summary disposition. The Michigan Court of Appeals reversed. We filed an application to the Michigan Supreme Court, and the Supreme Court granted leave. Upon granting leave, the Supreme Court issued a 5-2 opinion, but that 2, which includes Justices Viviano and Zara, that was a partial concurrence, partial dissent. But the majority opinion, which was written by Justice Kavanaugh, and it was joined by Justices Welch, Bolden, Bernstein, and Clement, it says that under our Supreme Court's jurisprudence, and what it was really consulting was what we refer to as the LaFontaine factors. The LaFontaine case was a case that sort of laid out the factors that we consider when deciding whether a statute should apply retroactively. And the court said, when you apply those factors to our case, the 2018 amendment could not apply retroactively to the events that occurred to Brian in 1999. Now, I'm not going to go through the entirety of the LaFontaine factors for everyone today because this is a very kind of specific practice area. But I will say is that one of the LaFontaine factors focuses on the statutory language and whether there is express language or indications in the statutory language that the legislature wanted the statutory provision to apply retroactively. And in this case, the court held that there was no such indication in this statute. And in fact, in subsection 3 of the statute that I've been discussing, there was retroactivity language included, but that language applied to a very specific set of plaintiffs that essentially boiled down to the plaintiffs who were assaulted by Larry Nassar. And so the Supreme Court said where the provision that I was attempting to proceed under and that Brian was attempting to proceed under did not contain retroactivity language, the statute couldn't be applied to Brian to make his case timely. Now, where the distinction between the majority and the partial dissent comes in is that the majority agreed with a position that I took in my brief, which is that when the legislature passed this statute, they essentially created a discovery rule for a certain class of sexual assault victims, and that modified the approach to when these causes of action accrue. Now, I don't think that the distinction between the two opinions is going to have much significance in the context of this case or future child sexual assault cases, but the dissenting justices took issue with that and said that a legislature doesn't amend an accrual date without doing so explicitly. And because this statute didn't explicitly say that it was redefining when criminal sexual misconduct cases accrued, the civil actions arising out of them accrued, that accrual was still governed by the general statute at MCL 600.5827. Again, I don't think that that's going to be a major issue of litigation going forward in the future. I think it's pretty specific to this fact pattern, but it could be something to look out for.
We don't have any pending questions, and with that, Tim, Mr. Chair, we'll roll right on back to you.
Thanks. Before hopping into my next case, I think appropriate Chris's comments made me think quite a bit when he's discussing how the court held that the legislature must speak very clearly in some respects, including making a statute retroactive or not. That same kind of heightened clarity requirement for legislative enactments was at issue in the Dahmer case and a case from a couple terms ago, McMaster versus DTE, where the court is showing not a preference, but more comfort with the common law and respecting common law rules unless the legislature comes in and very clearly overrides the common law. That was the issue in Dahmer, where the common law would not allow a wrongful death claim. So when the legislature did allow those damages, the Supreme Court just now said if they're going to allow additional damages above and beyond what was provided before, it must be clear. That sounds like that was the same ruling Chris had in McLain about retroactivity, and McMaster was the same thing. In McMaster, the Supreme Court reaffirmed the common law rule and said that a couple of legislative enactments were not clearly enough. There was not enough of a clear indication to overrule the common law. So that's one interesting feature between all these cases. Okay, now chiming into my third case is Bradley versus Frye-Chaiken. This case is more important for its public policy than the manner in which the court got to its decision. It's also a case where the Negligence Section filed an amicus curiae brief that was very well received and acknowledged during oral argument by Justice Welch. It was a brief authored by Tammy Sotoviera from my office and Charlene Turner from Seacrest Wardle. We were in San Antonio for the spring meeting, and this issue came up, and we kind of convened a mini amicus committee meeting and decided we should file a brief. Char was here in Michigan, Tammy was in San Antonio working remotely, and the two of them collaborated to put a brief together in no time. It was a fantastic brief, again, very well received by the Supreme Court. And those extreme circumstances kind of reflect the extreme situation in that case. The underlying issue in Bradley was it was a land deal gone bad. Plaintiff wanted to buy property in the Cayman Islands. Defendant originally agreed to sell it and then had a change of heart. And the defendant hired multiple attorneys. She kept burning through attorneys and raising kind of absurd and frivolous defenses to the contract claim. She also filed a counterclaim. Judge Timothy Connors of Washington County Circuit Court determined that the defenses raised by the defendant and the counterclaim raised by the defendant were frivolous. And at that point, I believe she had 3 different attorneys from 3 different law firms. After the plaintiff prevailed on the merits and the plaintiff filed a motion for sanctions because the defense and the counterclaim were frivolous, the defendant then hired a 4th attorney named Barry Powers, who came in. His only role was to defend the sanctions claim. He didn't raise any defense to the underlying case, didn't have anything to do with the counterclaim. He was literally there just to try to limit the amount of sanctions that were going to be awarded. Timothy Connors, to give complete credit, even though his ruling was reversed, he imposed joint and several liability for the frivolous sanctions to all 4 of the defendant's attorneys. Timothy Connors on the record seemed to say, I don't think this is particularly fair, especially to Mr. Powers, who had nothing to do with the frivolous defense. But he said, in a previous case, I didn't sanction everybody and the Court of Appeals reversed me. So I've got to do what the Court of Appeals tells me to do. And he did. And he imposed sanctions on all 4 of the attorneys, including Mr. Powers. It was joint and several. Michigan Court of Appeals affirmed the ruling. It went to the Supreme Court. By the time it went to the Supreme Court, our section, other sections, METC, MAJ, everybody came in and said, you've got to correct this result. This will have a chilling effect on people's right to retain counsel, especially people who are in a bad situation. Maybe they had a shady lawyer or an incompetent lawyer. Those are the people who need new lawyers more than anybody else. And if that new lawyer coming in says, I'm going to be saddled with whatever misconduct occurred before, they're going to have a lot hard time finding attorneys. I can speak for myself. We're a freestanding appellate boutique firm. We don't do trial court litigation ourselves. We come in after things have already gone on, long after the case has already been initiated. I know Beth and Mark Gonzato are the same way. Chris has in-house trial attorneys, but they take cases from outside all the time, coming to try cases. So for people like the 3 of us, it would be much more difficult for us to come in and take a case. Sometimes they come in an emergency. You've got to file an appeal brief in 4 days. Well, we'd have to, if the Bradley rule was still in place, we'd have 4 days to not only do the legal work, but also make sure that we're not going to get stuck with sanctions or any misconduct that might have occurred years before we had anything to do with the case. And thankfully, the Michigan Supreme Court, it was 6-1, but the dissent was very mild-mannered. It didn't really say that Barry Powers should have been sanctioned. That's not it. It was more, just as Viviano's dissent said, a trial judge should have some more discretion than we're giving the trial judge, than the majority is giving the trial judge. Again, 6-1 decision, reversing the sanctions, saying there's no basis for joint and several liability for an attorney who comes in after the fact and was not part of any of the misconduct. So there's that aspect that, you know, me, Chris, Beth, and everybody else can kind of express concern about. But like 6 months before this opinion was decided, the State Bar of Michigan, I got a notice from the State Bar of Michigan saying, hey, you must appoint a successor attorney. And I appointed a successor attorney who said, if I'm incapacitated, I get hit by a bus, somebody else is going to have to come in and clean up the mess. I'm also the successor attorney for other lawyers, some within my firm, some outside the firm. So the State Bar is creating this rule where every successor attorney is now going to be potentially on the hook for joint and several liability for every attorney they try to help out if Bradley was still good law. And thankfully, Bradley was reversed by the Supreme Court. It was an opinion by Justice Zara, and as promised, I will give what I believe to be the money quote. It's page 28 of the opinion. It's a little bit longer, but it's flag waving, so that's okay. Every litigant has an interest in obtaining competent counsel to defend their positions, and litigants would very much benefit from such competence when defending against a motion for sanctions or to replace a prior attorney who engaged in sanctionable behavior. The trial court's decision to impose joint and several liability on all attorneys who represented the sanctioned client, even if the attorney took the case after the sanctionable conduct ceased, could result in those litigants who are most in need of competent counsel to proceed pro se or hire even less capable counsel. That was, chef's kiss, music to all of our ears, the exact type of public policy rationale we'd like to hear from our opinion. From our Supreme Court in an opinion.
Thank you, Tim, and thank you for the fine work your firm, Secrets Wardle, did. And I will just add that the other component of the section's position that was submitted to the court was that in addition to not having joint and several liability for successor counsel who weren't involved in the misconduct, to allow for as the safe harbor that subsequent counsel can advocate for the good faith extension of law modification or abrogation of law and not take a frivolous position when doing so. And of course, that no bad law gets overturned or no changes in the law can occur without what appellate courts and appellate practitioners and civil rights practitioners do every day. So with that, thank you, Tim. Beth, we'll roll right back to you if that's okay.
All right. Okay. So the next case that I'm going to talk about in this one, it's El-Jamaly versus Kirko Manix Construction LLC. So this case addresses the common work area doctrine. I'm not going to go into a ton of detail on this case because it is very, very factually heavy. So just a little bit of background on this. General contractors ordinarily are not liable for the negligence of their subcontractors or their subcontractors' employees unless a plaintiff can establish a claim under the common work area doctrine. And in order to establish that the common work area doctrine applies, a plaintiff must establish that the defendant, either the property owner or the general contractor, failed to take reasonable steps to guard against a readily observable and avoidable danger that created a high risk or high degree of risk to a significant number of employees in a common work area. So in this case, the plaintiff was electrocuted and he sustained severe injuries while he was working on a construction site that Kirko was overseeing as the general contractor. The plaintiff was an employee of a concrete subcontractor, and he was electrocuted when a bull float, which is a long handled tool that is used to smooth concrete, he was carrying it and it made contact with or came near a DTE power line that was above him. So the plaintiff filed suit against multiple defendants, including Kirko and DTE. The trial court denied the defendant's motions for summary disposition, but the Court of Appeals reversed. With regard to Kirko, the Court of Appeals held that plaintiff failed to satisfy the requirements of the common work area doctrine. With respect to DTE, the Court of Appeals held that DTE did not owe a duty to plaintiff because the evidence showed that the power lines were in fact not defective and they were appropriately strung and all those good things. So the plaintiff appealed and the Supreme Court ordered a MOA in the case. Ultimately, the Supreme Court reversed the judgment of the Court of Appeals as to the common work area claim against Kirko. The court held that the Court of Appeals had properly defined the risk of harm as the risk of electrocution from use near the power lines of high-reaching conductive tools or equipment that is capable of reaching those power lines. The Supreme Court held, however, that the Court of Appeals had failed to recognize that there existed genuine issues of material fact by which the plaintiff could establish the common work area doctrine. So with respect to elements 1 and 2, the court held that the record was not conclusive that Kirko took reasonable steps within its supervisory authority to guard against the power line danger. They found that, they agreed with the Court of Appeals that Kirko took many steps to make the area safer, but a question of fact still remained as to the reasonableness of their actions. And the court held that the reasonableness of Kirko's actions in guarding against this danger is an analysis that is best left to the trier of fact. So it's a jury question, essentially. As to the third element, the high degree of risk to significant numbers of workers, the court again held that the Court of Appeals had ignored evidence regarding the risk of electrocution that was presented to other building trades on the job site. But importantly, and I think this is the big thing, that the Supreme Court held that there's no temporal limitation under the common work area doctrine as to when a general contractor can be put on notice of a danger. So we've seen this a lot in the arguments that are made by the defendants that, it has to be at the exact time of the injury. And the Supreme Court now has made it clear that's not correct. There's no temporal limitation. You've got to look at the entire time that this could be a risk while this job site is up and running. The Supreme Court also held that there's no requirement that someone first be injured or electrocuted before you have notice, because there was, in this case, a different contractor that had taken his, I think it was like a scissor lift or something, and it had actually severed the power lines previously. Nobody was hurt in that case. And they had said, well, it might have been a different part of the power lines. And the court's like, well, that's all factual questions. And, just because the guy wasn't electrocuted or killed, that doesn't mean that you didn't know that this was in fact a danger to other people that were on the job site. As to the element 4, the common work area, the court again found that there was evidence that established that multiple workers had to pass under these power lines in order to do their jobs. So essentially the court just held there are issues of fact and this has to go to a jury. As to DTE, the Supreme Court reversed the judgment of the Court of Appeals on the issue of duty. They said that whether or not DTE owed a duty rests upon whether or not contact with the power lines with this high-reaching conductive equipment was actually foreseeable. The court disagreed with the Court of Appeals that the lifting of this bull float on a vertical way by the worker was not actually foreseeable. And so they disagreed with that. You know, it's foreseeable. He has this long tool, he's using it, and you know, other people also have high-reaching conductive equipment as well. And the court basically said if the jury determines that the power lines were improperly maintained, and that evidence is going to show, or at least create a question of fact as to whether plaintiff's injury was foreseeable, and therefore DTE had a duty to protect plaintiff from the risk of those high voltage power lines.
You know, Beth, I am taken back to an article that Tim Diemer wrote for the State Bar Journal about the issue of duty and the general duty versus and factual developments and the role of the jury in deciding the issue of duty and the scope and extent of duty, factual disputes. And that really highlights the section's mission of promoting the role of the jury in our civil justice system to decide facts. And the
Yes.
proper role of the court as the decider of law and the jury as the decider of fact in a jury case.
Yeah.
So,
Yeah, exactly. So that just the court really emphasized that. So if this is particularly if this is an area that you practice in, I think this is a really good case to review. So, you know, questions of fact.
all right, Chris, you're
All right,
we
my
don't have any pending questions, so we're rolling right to you.
All right. My next case is we're moving out of the area of sexual assault cases. We're moving into a PIP case, essentially. So this is a case called the Estate of Charles Williamson versus AAA of Michigan, and it's MSC number 165131. I think this one is going to be very quick. So this is a case that involves the meaning of MCL 500.3173A sub 4. And so this is a case that went through the Michigan Automobile Insurance Placement Facility. Charles Williamson was a pedestrian who was hit by a car, or a car or a truck, but he was hit by a vehicle as a pedestrian. And the case went to the Michigan Assigned Claims Plan and was assigned to AAA. And so for approximately a year, I think that case almost was being litigated when Mr. Williamson unfortunately died in an unrelated accident 1 year later in October of 2019. I believe it was his daughters were appointed as personal reps for his estate and took over the litigation. And in the course of that litigation, they received interrogatories that asked them which months they were claiming attendant care services for. And within their response to those interrogatories, they claimed attendant care benefits for the months of November 2019 and December 2019, which were the 2 months immediately following Charles Williamson's death. And so AAA moved for summary disposition and argued that this is fraud in pursuit of a claim, which is specifically outlawed by the statutory section at issue. And the Michigan Court of Appeals said that the fraud provision in this statute only applies to acts of pre-litigation fraud. It has to be fraud before you've started a lawsuit, when you're simply dealing with the insurance company and trying to obtain benefits for yourself or apply for benefits for yourself. And the Michigan Supreme Court said that that's too narrow of a reading of the statute. And again, this is a case, while very factually specific, it does, again, come down to the specific statutory language. The Michigan Supreme Court said that the statute at issue simply speaks about making a claim and fraud in pursuit of a claim. And they said the word claim doesn't have any special meaning that is pre-litigation oriented. That once you're claiming to an insurance company that certain benefits are owed to you, that claim exists. And whether it's during the course of the lawsuit or before the lawsuit, if you commit an act of fraud, that can jeopardize your ability to pursue that claim or pursue a remedy. Ultimately, the court remanded the case back to the Michigan Court of Appeals, and because the Michigan Court of Appeals never had to reach the issue of the knowledge and intent of the personal reps of the estate, because they simply determined this statute doesn't apply to acts that occur during litigation. Because the Supreme Court disagreed with that, A remand is necessary to figure out whether this actually was fraud, meaning did the representatives of the estate actually intend to claim benefits for months they weren't receiving them, or was it potentially simply a mistake? The one thing I would say about this case is I think it just calls attention, and people who work in the area of PIP know this. You have to be very careful when you're making claims for benefits for your clients to ensure that those claims are accurate, that your clients understand the benefits that they're making a claim to, that all of the dates are completely accurate and correct. Because I think oftentimes when people are dealing with some of the forms that are involved in PIP practice and they're trying to figure out, when they're dealing with injured family members and they're trying to figure out which months they were receiving which benefits, mistakes can be made, and it's incumbent upon lawyers to make sure that our clients are ushered through that process properly to avoid problems like this.
And Chris, another point that has come up in discussions, including in our no-fault discussions among the section, is that this case is a narrow holding based upon a statutory provision that's specific to the assigned claims plan.
That's right, Chad, yeah.
Statute, and it doesn't overturn the published Haydock case that says in general, no-fault cases, whether if there's been a misrepresentation of some sort in the handling of a claim or in litigation, that is an issue where whether dismissal is appropriate as the ultimate sanction, whether there was fraud, whether it was intentional, whether it was material, whether it was relied upon, all of those things are issues for the court to consider, and that the court retains the appropriate jurisdiction to fashion an appropriate remedy based on whatever the alleged misconduct, if it is in fact occurred. This doesn't resurrect the old Bozzi, dismissals that we saw for so many years in PIP practice. That this was a very narrow holding based upon a specific statutory provision. Is that right?
Yeah, that's right, Chad. This only applies to this particular statutory provision, only applies to cases that went through the Michigan Automobile Insurance Placement Facility, the MAIPF, or the Michigan Assigned Claims Plan, and then was assigned to an insurer like AAA. And so if you're not dealing with one of those cases, this holding doesn't impact you. Although, of course, it's always, best practice to ensure we're being accurate.
Absolutely.
It's going to come up for impeachment purposes and a variety of other purposes if you're submitting documentation that proves to not be correct.
Well, great. Thank you, Chris. Before we wrap up today, there's a thank you that should resound for all of us. And that is for our administrative support staff at Shared Resources. Madeline and Matt Hinkle especially, and Tara, Owen, Ellie. The work of this section could not happen. The wheels would not be on this bus, but for the work of Shared Resources, Madeline Laurie, our executive director, and all of her staff that do so much to make sure that things run smoothly, our books are kept, things are done in order. I know Tim probably has had weekly calls, if not daily calls at times with Madeline to make sure that our section is efficient, productive, and one that serves its membership. With that, let me just double check to make sure we don't have any pending questions. As a final note, though, please do know that our panelists today, if a question came up, you can email the section. We'll be happy to forward that. And if there's some follow-up that's requested from the panelists, we will certainly take that into account. And now, without further ado, we have predictions of court cases that are come up because in our spring meeting in Puerto Rico, the first weekend in May, we will have the reveal of how accurate, how prognostic, how clairvoyant these amazing, brilliant lawyers are. They haven't missed one yet, by the way.
Well, I will start without specific case information, but I will say that there are a number of unanswered questions in the no-fault world from the reforms from, 5 years ago now, more than 5 years ago, the reforms when they were passed. There are still a lot of unanswered questions. Williamson addressed one, and Derry last year addressed a couple of big ones. There are there are 2 cases in the Michigan Supreme Court now on the reforms. One case has been granted, the other one's been held in abeyance. And the question is whether insurance policies that were in place prior to July 1, 2020. July 1, 2020 is the operative date when policyholders had to be offered minimum third-party liability of $250 per person, $500,000 per accident. Any policy issued or delivered after July 1, 2020 had to give the policyholder that option of whether policies that preceded July 1, 2020 automatically reverted to the new higher limits as of July 1, 2020. The Supreme Court has taken that case called Bonter versus Progressive. They are going to decide that opinion. That's a big one. There's one more, in full disclosure, my office is working on it. We filed an application for leave to appeal on the question of what, in cases of rescission or non-cooperation, when a policy is reformed to the statutory minimum, is the new third-party minimum liability $250 per person, $500 per accident, or is it a lower amount, $50,000 per person, $100,000 per accident? That's another big issue that has been percolating out there for a number of years. And it's going to be presented to the Michigan Supreme Court. Whether they take the case or not, it's anyone's guess. But that is an issue I think the Supreme Court does need to take up at some point because it impacts so many different policyholders. And the last one to conclude with kind of where I started and a little mini rant one last year, we have very little case law on trial tactics. The cases are from 2004 and even earlier than that. We have not had the Michigan Supreme Court say what's appropriate rules of engagement at trial in a very long time, because so few cases were tried, that I think that's coming next because the COVID backlog, those cases are now getting up to the Supreme Court.
Beth or Chris, any cases that you're gonna or issues that you see coming up?
Well, I think, like Chris had just mentioned too, like the intent to defraud, I think that's something that, the courts haven't really maybe looked at too much, or at least we don't have decisions on that whole analysis and, how that is gonna play out. I think we'll see. The other one too that is on my watch list is the C-Spine and Wallace cases. That is all about standing and real party at interest when you have these, I know they're referred to as shifting assignment type cases. So that's another one to really watch and see, because I know that that is a huge issue for a lot of trial attorneys and a lot of trial court judges as well, dealing with, who has the right and to bring these actions. So I think that one, that C-Spine and Wallace case, those two cases are going to be, I think, affect a lot of people, let's put it that way, in the practice of no-fault law.
All right.
One of the things that I'm kind of curious to see is when the Supreme Court gets presented with a case following Kendall El-Sayed that addresses licensees and trespassers. Because there was a lot of discussion when Kendall El-Sayed came out about how it essentially killed open and obvious. But I think as people got into that case, they realized it was limited to invitees, that the court didn't have opportunity to discuss the other categories of people who could be present on someone's land. And so I think that that could be something that's coming. And then one other thing that I feel like I'd be remiss if I didn't point out, it was a case that I was hoping to get to today, was actually a leave app denied that I think kind of foretells where things could be going, maybe not this next term, but maybe within the next couple, which is a case called GC versus American Athletics. It was brought as a public building exception under the Governmental Tort Liability Act, where it was a sad case involving a young boy who fell from some bleachers that at the time that they were built, they were compliant with the applicable building codes. But by the time he fell, they no longer were, because building codes had changed. And there's a distinction in public building case law under the GTLA about a failure to maintain and repair versus this concept of design defects. And I think that GC ended up not being the case for this court to take to address those distinctions, because this happened outside of a school on bleachers instead of inside of a public building. And I think that gave the court some pause. But I think that when that issue ultimately gets back in front of the Supreme Court in a different case, we could see a change to the court's case law in Rennie versus Michigan Department of Transportation, which is a longstanding precedent in that area.
Great. Thank you, Chris. In closing, let me just say this. Chris, Tim, Beth are some of the attorneys that are a few attorneys that are carrying a major load of the section's amicus work. My wife, Jennifer Engelhardt, Stephanie Arndt, There are a handful of lawyers that are really, Mark Ronzato, doing more than all of us. They carry this load and are doing the work of the section in our amicus arena, and Tim Diemer's been a steward for that. If you're watching this and you have resources at your firm, or you are willing to participate and help the section in its amicus efforts and promote the scholarship in law that is paramount to our mission, please reach out to Tim Diemer and make sure that we get you on a list and see if we can get a case assigned to you as well. Also, just one quick note, Bob Riley, thank you for getting our amicus guidelines and our institutional framework in order. What we saw, a balanced, concrete, credible approach to every case that the section has taken.